As a personal injury lawyer, I get a lot of questions about the Good Samaritan Law here in California. The Good Samaritan Law is found in Health and Safety Code 1799.102. The law says that if you come upon an emergency and you render aid to somebody, and you're acting in good faith and not looking for money, then you are not civilly liable for any damages. I'll give you an example. Suppose you come upon an accident and you see a person laying on the ground with a terrible leg wound. This person is bleeding profusely from his leg. You apply a tourniquet to the leg to stop the person from bleeding out and dying. And let's say the person survives but loses his leg. Then he sues you for causing him to lose his leg. Well, you can assert the Good Samaritan Law, and because of the Good Samaritan Law, you cannot be held liable to pay money damages. The reason for the law is that we don't want to deter people from intervening and providing aid when they come upon an emergency situation. We want people to help. We want them to be good Samaritans. Now, there are three important things to note about California's Good Samaritan Law. First, it applies to both medical and non-medical aid that you might render at an emergency. Second, it does not apply if you act with gross negligence. So, for example, let's say that you pull a woman out of her car after an accident, but you leave her in the middle of the street and a car comes and runs her over. The court might say that you acted with gross negligence by leaving her in the middle of the road, and therefore you cannot assert the Good Samaritan Law. Finally, the law only applies if you are acting in good faith and not seeking financial compensation. If your purpose in rendering the aid is that you are hoping to get paid for it, then the law says you are not really acting as a Good Samaritan. We hope this video has been helpful, and we invite you to subscribe to our YouTube channel to learn more about the law.